We have a quorum here tonight, and the first matter that we're going to hear is the Du Bois matter. And Saul, are you going to be representing the Du Bois?
Yeah.
Very good. I'd like to start off then by making sure that we're all kind of that there are two actual appeals that are on the docket with respect to the Du Bois and the Randrick Trust. Is it Randrick? Is that correct?
Randrick, yes.
Thanks. That was a good guess. The Randrick Trust matter. So I just wanted to, I guess, break those into two. There's the first appeal that relates to the notices of violation and orders to correct the date of October 12th, 2012 and the June 29th, 2015. And then there's also an appeal that relates to the notice of violation dated October 20th, 2015. So with respect to the notice of violation dated October 20th, 2015, I guess I'd like to invite, if I could, the code enforcement officer to just kind of start by giving us a synopsis of what entailed with that matter, and just kind of give us an outline of what transpired and what the nature of the violation was, so everyone will all be on the same page, please. Talking about the notice of violation with respect to October 20th, 2015.
They're both October 20th, 2015.
I guess I would refer the board and everyone to refer to Exhibit 1.
Okay.
And I guess that's really what kicked off that notice of violation.
When you say Exhibit 1, can you tell us what document you're in, please?
We are actually in our response to the appeal. Zoning Board of Appeals. I think the board received that on December 10th. And I guess I would refer to Exhibit 1, where we basically advised Du Bois Livestock that we felt that there were some clear and outstanding land use violations. We talked about the increase in the volume of compost based on information given to us by DEP, that they had in fact permitted a relatively large increase that we felt was in violation with the agreement between the Du Bois and the conditional use permit, and is in conflict with our ordinance. Basically, 5-time increase.
Okay.
We did not think that that was covered under the Right to Farm Act, and move forward with the notice of violation.
And how is this violation different than all the other violations that are stated in their subsequent appeal?
It really wasn't much different. The two previous ones were pretty much based on violations of local land use ordinance interpretation and contracts with the planning board on their composting facility. They were operating without licenses. There was clearly an increase. And there had been really no commitment to renew their permits.
Okay. And with respect to the appeal itself, the appeal then in your eyes is or the subject of the appeal in your eyes is to convince the Zoning Board of Appeals to overturn that order and find that the use is conforming?
That's correct.
Is that a
That's correct.
succinct?
Yes.
Okay.
Oh, I'm sorry. Was the find the use is conforming?
I just asked the question.
Yeah, I just didn't understand the answer because I don't know if that's what
No, I just asked him for his opinion. I'd love to hear from you.
no, I mean, we indicated that we, as a farm, have been a conforming use in the area we're in for years. I mean, but we've been told 1,000 times by the town that we're a non-conforming use. I mean, it's been repeated and repeated. Now, it just comes as a surprise that the CEO intends to overturn and change the use to a conforming use. But if that's what's gonna happen, I mean, we certainly don't have an objection to that.
Well,
I don't think he understands the response.
yeah, okay. So, why don't you go ahead and state for us, why don't you go ahead and state for us then what the basis of your appeal is, number one, and what you're asking for, what you're asking the zoning board of appeals to do, number two?
Okay, we've got two appeals, okay?
Right,
One consists of a revival and acceleration of a October 30th, 2012 order and a June 29th, 2015 order that just involves the Randwick Trust. Okay, it also involves Du Bois because they intended to have the, Bois Livestock perform whatever it was that was sought under the order. And if I could, it says, enclosed plead find copies of two notices of violation, which is the two we received, and orders to correct dated October 30th, 2012 and June 29th, 2015. Then it goes to the bottom and says, the town is providing the trust with an additional opportunity as the property owner to correct the violations that have been ongoing on its property since at least 2012.
all right, can we stop there for a minute?
Yeah.
Go ahead.
Well, I think, I'm now confused, because I do see this, I agree, I see there's two appeals. My answer to your question was on the latest appeal, the
Correct.
October 20th, 2015 appeal.
Correct.
I don't know of any other way to express this, but it's my opinion that the October 12th, 2012 and the June 29th, 2015 appeal, the right to appeal has expired.
I agree 100%. And that's why I was asking, that's why I was focusing on the second appeal.
Oh, okay.
Yeah,
Okay.
but the problem is they have revised it in relation to the trust. I mean, you brought it to the forefront. They indicated on the second page that we have until October 30th, if these requirements are not satisfied on or before October 30th, then the town will be seeking all available penalties, so on and so forth. So they have revived these two particular,
I read this as the town has made a separate determination with respect to the October 20,
Absolutely.
and that at this point, the October 12, 2012 and the June 29, 2013 issues are moot.
well, unfortunately, I don't believe that that's the case since they particularly raised them, okay? And clearly, they've indicated the town is providing a trust with an additional opportunity as property owner to correct these violations. They've accelerated it and revived them. I mean, I understand that there's been litigation over them, okay? Also, there's an issue of the fact that we contend that, back in December 9th, 2014, we complied with the June 29th, 2015 notice.
But you can't raise that issue as we sit here now in December of 2015.
Why not?
Those,
We're not attacking the fact that there was a notice issued, okay? We are raising the fact that we have complied. And I believe under the statute, we are permitted to appeal that, when he finally takes action. We're not saying that, with these two particular things at this point, okay, that they are in error, except for the fact now that they've accelerated, and we're gonna say they're in error. But back in December of 2014, we complied. We provided the town of Arundel with a application for a renewal permit, okay? That particular permit was supposed to be given to the planning board, okay? It was not. It was held hostage for months, okay, 4.5 months, okay? During that time, okay, they conducted a host of different executive sessions, they called them, okay, to deal with, the farm itself. So the problem is, we have contest that we have complied, okay, and we should be able to take testimony of the CEO and the town planner and whoever else we think we need to establish that at this hearing. And I mean, for the first one.
okay. So with respect to the with respect to the appeal of the October 20th, 2015 violation, I read your appeal. I didn't understand what remedy you're seeking. I didn't understand what you would like the zoning board of appeals to do. What are you seeking us to do? I didn't understand.
Well, we first raised the fact that that the actions that we took in relation to the composting operation has been in existence for over 30 years. Okay, we contend that we were grandfathered in, okay, and that based on that grandfathering, we are not required to get a permit. Secondly, okay, I don't know why they keep bringing the issue of preemption, okay, because we're not seeking preemption in relation to the ordinance. We are, the Maine legislature changed the Agricultural Protection Act, okay, which now includes, okay, all composting operations, okay, and the town can effect any ordinance it wants, okay, but it cannot enforce that ordinance as long as the farm is performing best management practices. Now, we're not saying we're a farm. We don't have to do that because the State Department of Agriculture and the Department of Environmental Protection has already determined that we're a farm. Okay, so, you know, we're well within the confines of the statute, and in fact, the issue of being a farm anymore isn't required. Composting was determined to be a agricultural product, and this all happened in June of this year, and it became law in October or November, or actually it was October, I think. Okay, solid law. And all we're saying is that under the circumstances, okay, based on the fact that we're following best management practices, these particular ordinances are not enforceable.
So you're saying that the land use ordinance doesn't apply to you?
The land use ordinance doesn't apply to us as long as we're using best management practices, yes. It's just unenforceable.
Okay, and it's the code enforcement officer's position that in fact the land enforcement ordinance squarely regulates them?
I believe we do, and I believe DEP licensed them as a composting facility. Solid waste composting facility.
No, an agricultural composting facility is what we're licensed at. Although that makes a very big difference. It's a critical difference.
Wasn't there an exhibit with respect to the DEP licensing?
Yes.
Back.
Yeah, thanks. Did you have, which one was it? I can't remember off the top of my head.
Exhibit two, which regulated the solid waste processing facility.
Now, understand something about the DEP licensing. We filed with the town of Arundel years ago in 2012, the very license we were applying for.
It's on
Along with
the
all the
Great.
vendors. We also posted it in the newspaper like we were supposed to. No one, you know, was surprised. Everybody got a copy. Okay. The town should have a copy of it.
So, with respect to that, then your position is that the DEP license is incorrect?
What do you mean correct?
You're saying the DEP license, as stated, is incorrect, that you are something different than what they claim you are?
We're an agricultural composting facility.
Okay, you're not a solid waste facility?
No, not per se, no, absolutely not. In fact, with the change of the composting and manure as an agricultural product, okay, we believe that changes in fact, it does change the entire condition of what we're doing out there as far as composting.
The DEP license, though, it clearly says it's a solid waste order.
No, it doesn't, it's not, it's a solid waste order because it follows, what? Yes, the DEP sent us a letter, you know, which we have included in almost every filing with you gentlemen and everybody else, that indicates that we're a farm, okay, and what we're doing is agricultural composting.
Okay?
Okay, I mean, and, you know, the definition of solid waste, we're no longer a solid waste facility in the sense that compost is now, by statute, been, you know, turned into a agricultural product.
Okay. I just want to give the chairman a chance to get up to speed. We had just started the Du Bois matter, Mr. Chairman, and we are just talking about the second appeal, which was dated, or which deals with a notice of violation of October 20th, 2015. If you don't mind? Okay. So, just to give you where we are, we established that there's one appeal, obviously, that deals with the notice of violations from 2012 and June 29th of 2015. Then there's the second appeal of the code enforcement's notice of violation from October of 2015. We were focusing on the October 2015 notice of violation, and the code enforcement officer had just given us kind of an overview as to why he finds the Du Bois in non-compliance with respect to it being a non-conforming use. And Saul was just giving us a quick recitation. I had asked Saul, since he's representing the Randrick Trust and Du Bois, I was asking him to explain, A, what is it exactly you're appealing, and B, what is it exactly you want the zoning board of appeals to do, because it's not clear to me and my fellow members of the board when you read the appeal exactly what relief they're seeking. And that's kind of where we are right now.
So first, I'm sorry I'm late. I had a trial in Belfast, and when the judge tells you at 4 o'clock that you cannot leave, the only correct response is, yes, ma'am, thank you. So, I'm sorry.
I tried that once in court martial. We pointed to two Marines, if you leave, they're coming back.
So you know what I mean.
Yes, you know.
And the court officers were staring at me when I was putting my coat on, saying, no, you're not leaving. So, John, since you kind of took the lead, I'll just listen and chime in when I
So,
finish.
getting back to our discussion.
Yeah.
So, the first point that he raised, Jim, just so you'll know, is that he doesn't feel that he's subject at all to the land use ordinance. He also feels that since there is and correct me if you think I'm wrong, he also feels that since there is a notice of violation with respect to October of 2015, that resurrects and breathes life into his appeal with respect to the June 2012, strike that, the October 2012 and the June 2015. And my position, just briefly, my own personal opinion was that that entire appeal is moot because it's well outside the 30 days and isn't up for discussion. And that's kind of like where you and I left off, so please, go ahead.
And I explained that, you know, the town itself has revived those two issues by sending, on October 20th, they sent out two notices of violation. Okay, the one that I'm talking about in relation to the October 30th, 2012 and the June 29th, 2015 notices of violation, okay, provides an important part here. Enclosed, please find copies of two notices of violation in the orders to correct dated October 30th, 2012 and June 29th, 2015. And then it goes on, and then it goes, the town is providing the trust with additional opportunity as property owner to correct the violations that have been ongoing on the property since at least 2012. And they go on and they list out what they want to have done. And then they give us, they say, if these requirements are not satisfied on or before October 30th, 2015, the town will be seeking all available penalties, not only from Du Bois, but also from the trust within the context of the pending Rule 80K action. So, and they bleed Du Bois Livestock into this particular notice as well, because they don't require Randrick Trust to perform the ordinance violation corrections. They expect Du Bois Livestock to do it, because it says, quite particularly, Du Bois must file all bills of lading and a summary report with the town as required by condition 7. Du Bois must contact me to arrange an appointment for the required annual inspection. Du Bois must submit a permit renewal application to the planning board that fulfills all required submission criteria. So it really reflects on all of the parties, even though it's directed to the Randrick Trust. But what I contend, and the farm contends, and everybody contends on our side, is that it has been revived, okay? Because of the fact that they have the right to do that. They can revive their own notices. I mean, that's not something we did. This is what they did. Okay? Whether by negligence or design it was done, it has been done. And we believe that that is a matter that we can appeal now because the date of that particular notice was October 20th, as was the other one. There's two October 20th appeal matters.
So I apologize if you've answered this question already, but I just heard this, you say about the revive. Tell me what authority or how you justify saying that this October 20th, 2015 letter by the code enforcement officer revives these prior decisions that were made in October 2012 and June 2015.
It's a notice of violation requiring us to comply with these, giving us an opportunity. And the fact that the notice of violation actually says, the town is providing the trust with an additional opportunity as property owner to correct the violations that have been ongoing on the property since 2012. That is clear language that they are reviving it, that they're bringing it back.
I guess I have to respectfully disagree, because, at least in the context of my world, if I commit a crime and I'm put on probation, and I commit 3 or 4 or 5 probation violations, and then I finally come within compliance with what the judge wants me to do, that doesn't relieve me from the acts that I committed prior. I'm not given a free pass on all 4 acts when I finally do it right the 5th time.
But we weren't in violation. Okay, there's not a probation violation. I understand probation violations, okay, because.
No, I just use that as an example, that
Yeah.
you clearly were found on those 2 occasions to be in violation, and you don't get relief from those violations now in 2015 because you've been cited for yet a 3rd violation.
No, the whole idea of it is, this is a citation by a town, okay, it's a civil citation. Okay, they have revived it, they've never brought it against the Randwick Trust, okay? So, they decided to bring it, and in that particular regard, the Randwick Trust has an opportunity to respond. And
Okay.
also, you know, the issue is not that, you know, a probation violation, okay, there's one thing that kills it, okay, is the fact that the person did comply with his probation terms, and it's exactly what we were talking about.
The intent was to advise the landowner that a violation, our opinion is that a violation existed on their property.
Okay.
That was the intent of the letter, was the intent of the language.
So are you here on behalf of the trust or on behalf of Dubois?
On both, this is a trust issue right now, and then
Okay.
we have the trust.
So then, let's just set aside the reviving and resuscitation issue for a minute.
Okay,
Thank you. So, as far as you and I are concerned, or as far as you and the board are concerned, tell us what you're appealing, and tell us what you want us to do. Let's kind of move on to those last 2 points if you don't
okay.
mind.
Now, all of these appeals deal with an issue of grandfathering, okay? We contend that, you know, whether we're a non-conforming or conforming use, okay, the fact that the process has existed for over 30 years, long before the ordinance was ever created, okay? We were a use, okay, that is grandfathered, and we shouldn't be required to secure a permit.
So your position then is that the code enforcement officer has no standing to even serve you with a notice of violation?
Because of the fact that we were not required to be, we shouldn't have been permitted in the first place. Okay?
Okay.
Now, I cited case law in the packet that I gave you that related to, you know, the constitutionality of grandfathering and its purpose and how it will be interpreted by the, you know, the main judicial Supreme Court, based on the fact that they will not interpret it to be unconstitutional, and we consider that the seeking of a permit, okay, was error in the first place, and it doesn't create precedent. Now, I also put a case in there for that. That deals with the grandfather. The second issue is the change in the law that occurred in June. Okay? In June, the Right to Farm Act was amended to include all composting facilities, and it also created a circumstance where composting and manure are now agricultural products. Okay. The issue, you know, I keep hearing the word preemption. We're not talking about preemption anymore. We're done with that. There's no preemption. But what there is under the Right to Farm Act or the Farm Protection Act, the farm, okay, cannot be held in violation of an ordinance if it's using best management practices. And what we're contending is, we're using best management practices, so we cannot be in violation of the town ordinances. And then we also go on and explain to the fact that we also believe that we were in compliance, okay, because of the fact that we did file an application in December of 2014, on December 9th. We delivered it to the town under the LUO ordinance, okay? The planning board was required to make a determination of whether or not we were complete in our application. Unfortunately, the processes of the town of Arundel is the application went from the clerk to the town planner, and he held on to it for 4.5 months. During that period, you know, we, on June 15th, he actually told the planning board that he had received it, and that he didn't believe it was complete. And we went through a whole, you know, deal of bias and prejudice in relation to that particular issue. But the important thing is, as we went forward, okay, the application never showed up. We were never told that it was incomplete. And the way we found out about the whole thing about April, I guess, that they were in fact holding our application without any explanation. And we ended up, you know, going through all these rows with the town until June, I believe June 5th, when the land of the statute was amended on June, I think it was June 10th or June 11th. And at that hearing, we asked the planning board in relation to our permit, if whether or not they would hear the fact that we believed that they didn't have jurisdiction or the ability to do what they needed to do to us based on the amendments that had been passed. They refused to do it. They refused to give us any kind of an indication. So we withdrew our permit. Then, when we withdrew our permit in June, on June 29th, we got another notice that you guys got to file a permit or we're going to come do this to you. So we filed the permit. Now, also, okay, we have never, during that period, okay, before June 11th, okay, we were trying to comply with getting the town out there, which happened to be the CEO and the town planner, to the farm, okay? Nobody was working hard at it, okay? Nobody thought it was a big deal, okay? But we never, ever told them not to do it, okay? And in fact, on June 29th, when we got the notice, he said, Mr. Nagel, a letter, hold on. It's dated July. July 9th. In our letter, okay, we responded to the fact that we had complied with whatever they wanted us to do in relation to that particular notice of violation. First off, we also told them that because of the fact that there was an issue involving farming and farm, that the Department of Agriculture had told us that when we had an inspection by the town, they were expected to be there. So we asked to have that particular circumstance actually happen. Everybody get together, then go inspect. This is all before June, okay? Now, also, bills of lading. I do not know how many times we have told everybody we just don't have bills of lading. They are a particular type of document, okay? We don't haul freight for anybody else. Nobody hauls freight for us. When it comes to moving the product, we go get it ourselves. Okay? I also understand that everybody wants 1 day's notice to get the product. Okay? There's no way we know when, one day ahead of time. They call us, we go get it, okay, or it shows up. We don't have that particular kind of control. We brought that up at the planning board meeting, just like, to be honest with you, the very first issue on your, or finding of fact and requirement on our original license that we used in 2011 was that we should dredge, okay, out this basin that we have, of all the silt and all the vegetation. If we do that, okay, then the DEP will come down and shut us down. We told them at the meeting, we can't be doing that. We just can't do that. It was okay, everything was fine, nobody said it was gonna do that to us. We told them we didn't have bills of lading. They said it was okay, they were still gonna put it in, but they knew we couldn't comply with that. We told them about the one-day notice. We don't have that, okay? Now, understand something. When you look at the license, you'll see that we made an application in May of 2010. Okay, 9 months later, we were finally able to get a license. Okay, we went to meeting after meeting after meeting, explaining exactly what we were doing, how it worked, what we were supposed to be doing, everything. There's been no deceit on our part. And then they turn around and say, well, you guys have to give us bills of lading. We don't have any. Yeah, and the DEP, this letter also informs the CEO that we have given them the documents that they wanted. The total volume, we have to give that to the DEP in March. Their requirement is for us to give it to them in March. We've given them. They turn around and say, well, we don't have it. So we gave it to them again. I know that happened because I walked in there with Marcel with those documents, set them down so that they would have them. And still, they keep after us because they don't have them.
So if you're, so I guess I'm a little confused. With respect to the last 7 or 8 minutes of explanation you've given to us,
Yes.
that all goes to the use of the land and the licensing, correct?
And in fact, we did comply like we were supposed to.
But your initial contention was that you don't really need to comply because it doesn't really apply to you?
No, now it doesn't. Okay, we're certain.
Because they changed Title VII?
Because they changed Title VII, and we've never raised the grandfather clause, which we have a right to do.
And where can I find the grandfather clause that applies to you? Where do we have the authority to rely on the grandfather clause? Because I honestly looked and couldn't find it.
Well, the one that they have is a non-conforming use. It's section like 5.1, I believe. I put it in the, now, understand something, the land use, no, she's not land use, but the planning board recognized the fact that we were, were an exempt type of a business because they put in their own conformance with conditions, use criteria. And it was, when did we get this application? It was on February 24th, 2011. They say, the proposed use is not similar with other residential, I can't read that word, in the district, but is consistent with the operation of an industrial mixed-use farm complex. The use is not permitted in the R4 district, but is a pre-existing, non-conforming use that cannot be expanded beyond the boundaries established of this conditional use permit. We of course contest that they can.
All right, so just to stop there for a minute.
Yeah.
So you can see that if you look at if you apply the land ordinance and if you apply the license to your outfit, you've exceeded the use. I mean, you've exceeded the volume that you've exceeded your footprint and you've exceeded volume of waste?
No. We've never exceeded our footprint, never. We're in 6 acres, always been in 6 acres.
And you have not,
We have a license to increase our volume. I do not know if we've ever surpassed the volume that would be permitted by the town.
okay.
We have a license to do that, but we have never, ever extended our footprint, ever. It's in that box. Okay, also, we provided case law that indicates that an increase in volume, okay, is not a violation of a non-conforming use.
And where do can you point me to a statute, either state or federal, that says that the zoning board of appeals can preempt or can give you permission to operate when it may be in violation of state and federal law?
I mean, in violation of state and federal law.
And if your operation is a violation of state and federal law, do you know of any authority we have to allow you to continue to operate?
If we're in violation of state and federal law,
Hmm.
we're not in violation of state and federal law.
So your position is you're not in violation of the DEP license?
No,
And that because of the Maine Agricultural Protection Act gives you the right to do what you do?
yeah, but we're not in violation of our license.
Okay,
I mean, I don't know where you got that.
okay, no, I'm asking.
No, we're not. We're not in violation of our license and never have been. Okay, we've amended it, we fought over it, we've done everything else in the world with it, but we're definitely in compliance and always have been.
Does anyone want to ask any questions that I may have?
I do. So John just asked you to cite to him where this grandfather statute of laws.
Yeah,
I've read your application, or your appeal application several times, and you cite the land use ordinance 5.1. You call it the grandfather statute.
that's as close as I can find.
So I've got it right in front of me. I don't see anything about this statute that calls it the grandfather statute. So
Well-
why do you call it that?
Because that's just a general name for that type of a statute. Okay, under the state, you know, case law, it calls it grandfather, you know, as opposed to any other state, it's just what it's called.
All right, so make sure you and I are on the same page. So on 5.1 of the town of Arundel's land use ordinances, general provisions, non-conformance, right?
Okay, then non-conformance, I also believe that would be interpreted, okay, to include, you know, other types of use because of the fact that it cannot be interpreted to be unconstitutional. You have to have a grandfather clause in your land use ordinance. Otherwise, you could create a taking and you violate, you know, I forget which amendment it is right now.
All right, so you've said a lot. I just want to keep us focused. I want to stay on this grandfather issue for a little while, okay?
Yeah,
And I wrote it down. If I didn't hear you right, you correct me. But you also said in your presentation that the company never should have even been granted a permit to begin with.
we should never have been required to secure a permit in the first place.
When was the first time you secured a permit?
Oh, it was years ago.
How many times did that permit get renewed?
I don't know how many times.
So if it got, but it did get renewed multiple times, right?
Yeah,
So if it got renewed multiple times, why all of a sudden is it now grandfathered that it doesn't need to be?
because the grandfather doesn't disappear. The findings and permitting of a town entity does not become precedent. Okay, I believe I cited the case in the document that I gave you guys.
Yes.
It should have a case that explains that, you know, that it's not precedent. And the fact that they made mistakes and required it when they shouldn't have, does not create, okay, a right to now require it when it's grandfathered.
Does that mean you guys also made a mistake by continually applying for the permit?
Absolutely, absolutely. Okay, there's no question about that.
And before I move off the grandfather issue, with the exception of you citing 5.1 of the ordinance, you cannot cite anything else that supports this argument that it's grandfathered.
I don't know of any other statute in the ordinance, but there probably is one. There probably could be one. But it's the fact that, you know, it's really a requirement, and otherwise, I don't believe that, you know, the annual application to us would be constitutional.
And the other question, so I'm going to move off to a different topic now. The other question that I still haven't really heard answered, at least to my understanding or satisfaction, is how this most recent letter from the CEO basically revives or renews these prior violation notices.
Well, I believe the language of the violation of October 20th, which is, they're both October 20th, okay, indicates very clearly that it's the intent that these violations, or these notices are being reopened, okay, for the very purposes of compliance. I mean, that's what he said, and then he says, you have until October 30th to get it done. So that's a revival. And it accelerates it to the issues now at hand, which we deal with grandfathering and the amendments to the right to farm act.
Isn't it simply giving the property owner additional time to correct violations?
Yeah, the October 2012 violation and the June, 29th violation. Yeah, those, are bringing it forward.
But the letter itself actually cites that there have been violations, at least according to the CEO, since 2012, correct?
Oh,
It
well,
says that, right?
Yeah, that's what it says.
And it says also that it's giving the landowner an opportunity, by notice dated this time in October, we're now giving you more opportunity to correct these violations.
To comply with the October 12th and the June 29th violations. Particular violations, not anything else out in the world. He attaches them to the document.
Did the boys receive the notices of violation of October 30th, 2012 in that time frame?
Yeah, we all got this thing.
No, in October, on or about October 30th, 2012, so 3 years ago.
Oh, yeah.
Did you receive notices of violation?
Yeah, we took it up on appeal. Okay, and during that period, it was set in abeyance while we were wrestling around with it.
All right, and what was the result of that appeal?
The appeal, we appealed the issue on preemption, okay? And it was found that there was no preemption.
Is that the case that went to this court
Yes,
and then went all the way up to the law court?
yes.
All right, so that's been resolved, right?
Resolve this to preemption.
So the law court in our state ruled against you, right?
Oh, now, hold on, now, when?
I just want,
No.
I do want to control this because you're saying a lot, so I want to stay on one topic at
Yeah,
a time.
I do too, but,
And I'm going to give you opportunity, so
Okay.
just answer that question.
okay,
Did the law court rule against your
on
appeal?
preemption, yes.
Right, so, and do you think that this zoning board of appeals can revisit that issue and change the law court's decision because of an October 30th, 2015 letter? Is that what you're suggesting to us?
No, we're not, the issue's not preemption. The court also indicated, okay, the court also indicated, okay, in that particular same thing, okay, that the Right to Farm Act was effective, okay? And as long as a farm at the time, okay, used best management practices, then the ordinances were not to be applied against that particular farm. Of course, they turned around and said we weren't a farm, and that, was just absolutely shocking. Okay, I've never seen such a thing, because of the fact that, Marbury versus Madison clearly indicates that the separation requires that the legislature make those determinations. And I can tell you, okay, the Department of Agriculture went crazy over that. Okay, that's why they wanted to show up at the farm when there was an inspection, because they wanted everybody to know that we were a farm, and they had made that determination, and they were the ones that should make that determination.
So let me ask this all the same question about June 29th. The June 29th, 2015 notice of violation, did the boys receive notice around that time frame of the violation?
Yes, we did.
And what did you do in response to that, if anything? In other words, did you appeal it?
No, we sent them a letter.
But did you appeal it to the zoning board of appeals?
We didn't, there was another issue of appealing. At that time, we were talking about whether we had complied. Okay? And this is the June, there's a letter, July 9th, 2015. We said we complied, explained why we complied, and told them that, get a hold of us. This idea that you're gonna call up the CEO of Arundel and get the guy on the phone is tough. Okay, he's busy, he's all over the place. He's very hard to get a hold of. Okay, we wanted dates that we could do this. We tried a couple of times. One time he set the date for what's that, Labor Day, I believe it was?
Labor Day, I erroneously gave you a Labor Day date.
Yeah, and that's okay. I mean, pick another date. Find us some other time we can get a hold of this guy and have him show up to have that particular inspection.
Well, those are my questions on those two issues.
So, with respect to your being designated as a solid waste facility by DEP, have you ever done anything to modify or have that changed, or does that designation still live?
No, we are an agricultural composting operation. Okay, when you look at the license.
No.
Yes, we did. We had, it's important that the difference be understood. Okay, you can't abuse the expression solid waste. It's not one definition. Okay, it's very broad. Okay, and it encompasses everything. Okay, Now, the issue.
So I guess my question was, does that license still exist?
Our license,
Yeah, with DEP.
amended, yes.
Okay,
It's been in existence for 30 years.
thanks.
We also have a letter stating that under our license, it's an agricultural composting license.
Yeah,
And they take away a license to compost, it's an agricultural product.
yeah, there's a
From
particular
DEP.
section of the DEP that deals with agricultural composting separate from everything else.
Now, before I got here, did you give the CEO and town planner any opportunity to respond to any of this, or are we still just hearing from?
No, in your style, I did.
Have you responded?
No,
to
you know, that's kind of where we're at now, is I think we ought to give them a response.
Oh, I'm sorry.
No, you take right on.
Ted, do you want to respond to
I think
anything?
we'll tag team,
Okay.
if possible. I think we should first deal with the issue of the non-conformance, because that seems to be a big question here. This operation did exist prior to changes that occurred in the zoning ordinance. This operation was required by DEP to file a solid waste permit back in 2000 because they were operating without a DEP permit. At the same time, the town instituted a solid waste permit regulation as well within its zoning ordinance. It's been modified several times since then. It basically followed the state DEP solid waste ordinance. Provisions were the same sort of classifications. What the town, and essentially the town licensed at the same time they received the 2000 license, the town also gave them a conditional use permit for the activity of doing basically solid waste composting, what they call a solid waste processing facility, in that they're composting material that's not associated directly or produced directly by the farm. And you'll probably notice in our presentation to you, we gave you the definition from section 2.2 of what constitutes a solid waste processing facility. But I'm getting a little bit off it. They renewed that application a number of times, from 2000 all the way up to the latest provision in 2011. Somewhere around 2007, the townspeople changed the zoning ordinances in R4 and made the use of a solid waste facilities prohibited in the R4 district, transferred it over to the BI district. So in the BI district, we have a place where you can do solid waste processing. The only thing that remained was agronomic usage of residuals that can be spread on farm fields, but it's still needing a permit from the town as well as from DEP. The issue is that it's been a non-conforming use. It's been a legal non-conforming use since those zoning changes occurred. And they received permits for a limited amount of product that they could produce. Because of the non-conforming statute, and because of section, I believe it is 51B4, you find that on page 2 of our presentation. A non-conforming use of land may not be extended into any part of the remainder of that land. Basically, it's saying that you're frozen as a non-conforming use, you're frozen into your existing permitted use, and in terms of the intensity and in terms of also the expanse of what you're doing on that land. They were issued permits for about 5,000 tons of material during all those permits, including the last one in 2011.
And let me just interrupt, isn't that, let me ask it differently, from your perspective, is that what the October 30th, 2015 letter was? Letting them know that they're in violation, according to at least you, by expanding this non-conforming use?
Correct. They expanded the non-conforming use without, first of all, in violation of this particular section of the ordinance, but also without benefit of a planning board permit, which is required for any kind of conditional use, and especially any attempt to expand the conditional use. So that was the basis of it. It was four items that you noticed in that notice of violation. It included basically the expansion of the tonnage from around 5,000 to 29,000. It included the expansion of a bituminous pad, as shown on DEP application, referenced in the DEP site order, also shown on a NRC as-built plan, given to the DEP, showing a 30,000 square foot bituminous pad that was in addition to the existing 1 acre pad. Or the existing pad that's out there, it's not an acre, excuse me. Yes, it's within a designated composting area, but the pad is the area in which the composting operation of the mixture occurs. The 30,000 square feet was a significant increase in the area and the volume that was going to be produced. It was beyond what was permitted by the planning board in 2011. So that's part of the basis. Then, of course, the other things regarding compliance with the original conditions of the planning board permit in 2011 are also set. But the principal issue was the major expansion of non-conforming use without permits and in violation of the zoning rules. In addition, there was in building the pad, over 100 cubic yards of earth material used in the excavation and the construction of that. And that requires under our zoning ordinance, under our site plan ordinance, a permit from the planning board for anything that exceeds 100 cubic yards of material that is not associated with a permitted construction project. So it's a separate permit that the planning board issues every site. Those are the basic issues that Jim cited as the basis for the October 20th interview.
Did you want to, I'll get to you, Saul, did you want to get to that? Did you want to add anything to that, Jim?
No, I think that covers it pretty well.
Jim,
Okay,
I just wanted to ask Jim, with respect to the DEP order that was from January 2012, was that ever complied with, to your knowledge?
I don't know. I've only had conversations with Mike from DEP, and my understanding is that the expansion did in fact take place. We have not been on site to verify.
Thank you. Appreciate that.
But we do have the as-built, which is an as-built of survey showing exactly what was built. It was done by the federal NRCS.
And before I let Saul respond, and I will let you respond, I just want to make sure I'm not missing something very obvious here. This NOV, this notice of violation, it's the town's position that these violations occurred at the same time that no request for permission was made and or granted. Is that right?
Correct.
Okay. All right, Saul.
Okay, first off, I want to indicate that the composting on the park started about 1980. About 1998, the DEP came in and said, you guys have to have a license, because they had changed their regulatory provisions in relation to composting. So that's when you ended up getting a license. Also, the pads mean nothing when it comes to mixing, okay? We can mix anywhere on that entire 6-acre area that's out there because of the Elmwood soils. It has nothing to do with the pad. The pad that we put out there, okay, for just mixing convenience only. They did not expand the area where we can mix or hold our product. Okay? We can hold it anywhere. In fact, the NRCS, which they have, indicates that it was not done for the purposes of mixing. It was done for the purposes of creating a place where we can, if we decide to pile our stuff up, okay, we can mix it anywhere in that acreage.
Let me ask you this, so because the town has made very specific allegations as to the non-conformance and compliance, and I'd like to go through them with you rather quickly, but I want to go through them with you line item by line item to see what your response is, okay? So you just heard it, you heard that summarize it, but I want to see if you're going to say yes, that occurred, or no. Let me say it different. I'm not asking you to admit that you violated, I just want to ask if you've expanded use the way they allege you expanded use, okay?
No, well, not generally, not, they said no.
All right, so the first one is that they're saying that you went from 1,733 tons of type 1 fish waste, and you expanded it up to 8,000 tons, is that an allegation?
We became licensed to expand it to that much, yes.
All right, so you did expand it to 8,000 tons?
No, we expanded the license that much. At this point, okay, we haven't, we've hit that particular mark yet.
Okay.
But we certainly intend to, okay.
And what kind of license are you talking about?
Okay, well, here's the thing, okay? In order to secure such a license, okay, we're required to file with the town and everybody else, okay, and give them an opportunity, okay, to object to the expansion. This was in 2012. Now, we had to do this particular operation twice, okay? Because we sent out notices, brought the thing to the town, and the DEP wanted us to change a couple of things. So they sent it back to us and said, start over. So we started over, okay? And we gave them all the notices that were required.
That wasn't my question. You said you have a license. I want to know, what's the license? Who gave you the license?
The Department of Environmental Protection.
And they gave you a license to go up to 8,000 tons?
Yep.
Okay. So the next one that they say that you've done is that you, this is number 2. I don't know if you have this, by the way. You have the town's written response to your application?
Yes, I got it down here somewhere, right?
All right, so if you look at, Saul, at page 5 of 10, that's where I'm getting this information from.
Okay.
It says that the appellant has expanded the permitted 5,000 square foot pad to a second additional 30,000 square foot pad. And I think I heard you say the pad has nothing to do with anything. But I just want to know, did you expand the pad the way that you say you
We
did?
didn't expand a pad, we put in a pad.
So you added a pad.
We added a pad.
And how big is that? Was it another 30,000 square feet?
Absolutely.
Okay.
And it was permitted by the NRCS, and it was licensed by the DEP. Their engineers came down, checked it all out, we did everything you could possibly think of.
Okay. Did you then deposit more than 100 cubic yards of earth material when you were putting in that new pad?
Oh, just a second, I'm sorry, what'd you say, Randy?
When Wayne was here, you
Oh, yeah.
mentioned you guys, he was working with us on.
Yeah, Wayne, we had a meeting at the planning board, and Wayne told us exactly what we were doing with the pad and everything else, okay?
Right. Did you then put down 100 cubic yards of earth when you were putting down this new
You
pad?
know, I have no idea, I don't think so, but I mean, I have no idea about something like that, okay? I don't even know how they know.
And I've heard about the bill of lading, so I don't need to hear that. Your position is that you don't have them.
We just don't have, we don't create them.
Okay, I get that. How about the allegation that you failed to file all of the annual summary reports from 2012 to the present?
Absolutely false, done it every time. In fact, I
Do you
brought
have
us,
them? Do you have any copies of them that we can
not with
see?
us here, no, but because we give them to the town.
Okay.
We drop them off at the town exactly where we're supposed to, and then they turn around and say they don't get them. We've done it 2 or 3 times. The DEP has them, we tell them, if you guys can't find your stuff, go to the DEP, they have the exact same thing.
Do you guys have copies of these annual summary reports?
Then you have lost
I
them.
do not have them. I do not have them.
Do you not have them because you had them at one time and you misplaced them?
I have
Or are
never
you saying you
had them.
never have them?
I have never received them. At one time, one of the ladies from the group came forward with them, and I suggested she bring them to the planner. But and basically, I couldn't receive them, it wasn't my place to take them. And they were brought in, I believe, as part of an application process for the planning board, and that was my reason for not wanting them. I thought it was important to be delivered directly from her to the planning.
So when you say one of the ladies, you mean the ladies from Du Bois?
One of the representatives, yes. And that was many years ago. That may have been back in 2010. I don't even know if it's in reference to these particular listed violations. But on one occasion, I did have that conversation, and I remanded her to the planner's office and actually suggested that she get a receipt.
All right. How about 2013, 14, or 15? Have you received, has there been an attempt, to your knowledge, to deliver those types of annual
I
summary
have never
reports?
received anything, nor have I spoke to anybody about taking receipt of them.
I'd ask the chairman, how are we supposed to make sure he gets it? We're supposed to give it to the clerk. They have no method or mechanism for determining what they get, where it goes, or anything else. A perfect example is our December 9th renewal application. It sat in his office for 4.5 months.
To your knowledge, when you either deliver these or attempted to deliver these annual summary reports, did you get any type of receipt or written acknowledgement or date stamp or time stamp?
You
anything
never
like
get
that?
anything for anything you file.
Do you have anybody with you that can tell us that they delivered those annual summary reports?
I was with him.
So you brought it?
I brought him.
Who's the woman that Jim's talking about?
It has to be sitting with her. If you're talking about 5 years, she doesn't bring those things. We do.
Did you bring them in 2015?
Absolutely.
When?
Oh, excuse me. Yes, we did.
When?
Huh? I can't tell you, but it was like in March. When we do everything with March, we sent the one-off thing, I took it, okay, and I grabbed Marcel that day too, and waltzed in there and gave it to him. The second time that they lost it, said they didn't have it, we came back in and said they lost it, here's another one.
Okay. And Mr. Du Bois, you confirm that?
Yep.
And did you bring up an annual report in 2014?
Yep.
Same time frame, March?
When we had the lawsuit, we had to bring several in at once after the lawsuit. I remember that. And then every year after that. I mean, it's something that we just do. I mean, there's nothing to hide with it.
Okay. Let's go to the next one. The town's position is that Du Bois has failed to notify the planner 1 business day in advance of any deliveries of type 1 material in violation of condition number 5 of the conditional use permit.
And we had a remedy, which we explained to the planning board. I'm sure they don't remember, okay? Said, we can't tell that. Okay, but what we will have to do is to send you guys notices every day that we think we might get some. Okay? And they said, no, don't do that. Okay? But I mean, we just don't know a day ahead of time. It just doesn't happen there. They call us on the phone, we go get it. Or they call us on the phone and say, we're bringing it now.
All right, so because of logistic reasons, my word, not yours, that there are times when you don't give them a day's notice.
Can't. Yes.
Because you cannot.
You cannot. And we told them that, guys. I mean, it's like, we're explaining what we're doing. This process went on for 9 months, okay? We saw these guys every couple of weeks or so. Every once in a while, nobody'd show up and we'd have to leave, but I mean, most of the time, the guys were there.
Let me ask you a question with respect to that issue. Thanks. So when the truck comes, how do you know what's on the truck?
How do you know what's on the truck?
We don't know data.
But when you get, is there some kind of paperwork that shows what's on the truck?
Boy, I doubt
Like
it.
a bill of lading?
I mean, no, a bill of lading is something when you're hauling freight that the middleman gets and hauls it. If we had somebody else hauling our stuff for us, okay, we could somehow get a bill of lading. We don't, we haul it all ourselves, except when these guys haul this stuff. Now, understand, it's fish waste. They're not gonna waste any time bringing it to you, okay? It smells.
Okay.
I mean, you can blame for all sorts of
This
pieces
may
now.
be a really dumb question, so
Yep.
I protect myself in advance by saying that. But do you pay for this fish waste?
No,
So it's delivered, you don't get any kind of receipt, or you don't give any money, so there's no recording of it that way?
we don't pay anybody, I mean, anything for that stuff.
Do you get any money for it?
Oh yeah, we do get money for it.
So what do you get for it?
Okay, yeah, at the end of the month, we get a bill thing that's sent to us, for what we've hauled. And we put that thing on that big list, and we send it every year to these guys over here in the DEP, and we give the town of Arundel the exact same list.
So I want to make sure I can trace that. What you're getting, does it have a price for each truckload that has come?
No, we just get a bill.
What's the bill for?
In fact, I think we send them a bill, I can't remember exactly the process that we use, but that's our method, okay? It's not a bill of lading, it's just, it would just be, some kind of a scratch thing that we use to get our money for the hauling of the damn fish waste.
And I assume you send a bill for each time it's delivered?
No, absolutely
Do
not.
you wait sometimes after like 10 deliveries and then you send a bill?
Well, it's usually monthly or something like that, depending on how we decide to do it.
And does the bill reflect however many deliveries there've been?
Yeah.
How come you can't give that to the town?
Because that's not a bill of lading, and we're not required to do that. Understand something, okay? There's an issue of whether or not we run our business or the town runs our business.
I understand that, I'm not trying to get you worked up, so
I know,
I'm just trying to get a sense of what's going
I
on.
mean, we're trying, they want to know of nitrogen, releasing things, okay? We have that stuff tested all the frickin' time, okay? I mean, it isn't like we aren't regulated.
The brook and all that.
Yeah, we have these guys, they test the brook, they test everything. Nothing goes without being tested.
But we're all on the same page that at the end of the month, you know how many trucks have come,
Oh, yeah.
and you know what the capacity of the truck is,
Yeah,
and you know what you're getting per load, right?
yep.
Okay, thanks.
Sorry, yes.
John DeKinder, and I was on the planning board when the original permit was negotiated with for the composting, and since there's a lot of discussion about the bill of lading, there was quite a bit of discussion on the planning board at that point. There was a lot of back and forth. The planning board wanted to know how much material was coming in and what the material was. And we discussed various methods back and forth, and we all agreed that a bill of lading, and the Du Bois agreed that a bill of lading was the best way to do this.
No, we
Which is
didn't.
what-
No, we didn't.
No, good,
There's
agreed.
no way.
Agreed the same thing you said DEP.
I was on the board at the time.
We have a license.
Just let him finish, and I'll let you respond, okay? Just don't interrupt him, though, let him finish, okay, go ahead.
I was just about done. They agreed, and that was part of the condition of the permit, that bill of lading be supplied to the planning board. But there was a lot of discussion, there was ultimate agreement that that was the best way to do it.
And again, it could not possibly have been that way, because the bill of lading does not tell you.
You weren't there.
Hey, excuse me, I was too there. Excuse me, I was there all the time.
That
Oh,
was
absolutely.
before you,
Huh?
before you.
No, it wasn't before me. Okay, I know very well, okay, what happened in that particular thing. I was there. Now,
Well, you can, no, I
Okay.
won't say.
okay, we bring in exactly what our license says we can bring in and nothing else. Okay, everything that we bring in is determined by the license. It says exactly what you can bring in, okay?
So I want to ask you something.
Sure.
You made a comment that's very interesting to me, is that you want to run your business, and you don't want the town to run your business for you. Right? You said that, right? I mean, I'm not.
Yeah, for instance, you know, it's one thing for reasonable regulation, okay? And to some degree, I think the regulation of the DEP can get a little bit unreasonable, okay? We test our water, okay? We test our product, we test everything. Whatever it is, we supply these guys with every test that you can think of, and it's, anybody can go see them.
So here's my question, it's a simple question,
Yeah.
which I hope prompts a simple answer. Are you taking the position that the town has no right to regulate your business in any way, shape, or form?
I'm saying, no, we have 4 or 5 different kinds of businesses in that area, okay? And the town regulates all of these particular businesses, okay? What we're saying in relation to this is that if we're performing best management practices, okay, they shouldn't apply. Also, we're talking about grandfathering, whether or not we have to get this permit. We're not trying to say, we're trying to avoid regulation. We can't. The DEP regulates us to an extreme.
And do you agree that the town has a right to regulate you as well?
No,
That's the answer, I wanted to hear your answer. to
No,
that question.
no,
So your
because-
position is the town of Arundel has no legal right to regulate the business at all?
based on the grandfathering clause and the statute, okay? In relation to the composting facility.
And I'm one vote, as you know, but I'll just tell you this, as everything I've read, which I've read carefully, everything you presented tonight, I put no weight on this grandfather thing. I'm one vote, but I don't get the grandfather argument at all, and I candidly don't agree with it. So, at least with respect to me, you're gonna have to convince me of other things, because the grandfather thing is going right past me. You haven't supported it, you cite 5.1. That's the land use ordinance, not grandfather statute.
And the 22 months that you operated without a valid permit,
Oh, wait a minute, there is a state statute, I'm almost sure. But anyway, go ahead, sir.
I'm sorry, I didn't mean to interrupt you.
Go ahead.
I apologize. The 22 months that you've operated without a permit, your position is, we can do that because we're not required to be permitted at this point by the town of Arundel.
No, we're going through the permit process,
Okay?
okay? We filed permits, okay? We were trying to get things together. They are insisting, okay, one of our reasons we cannot get a permit is the CEO is required to prepare a report, okay? Which really shouldn't be seen by the planning board because of the fact that, we think it would create bias. Irrespective of that, okay, he hasn't prepared a report. We sent him letters asking him to prepare a report.
And so you understand that in the notice of violation, that issue number 4 was that you operated 22 months without a permit, right? We're all in agreement on that, but that's your...
No. We operated, okay, in the sense that the way it's being stated, I completely disagree because it has a slanted intent, okay? It makes it sound like we were not trying to comply, okay, all these months, okay? If we didn't have a permit, okay, it was because it was excused or we were incapable of getting it based on the town's determinations. We should perform certain functions that we could not do. And the fact that we wanted an issue resolved in relation to the Farm Protection Act. I don't think that's too much to ask. To find out from the planning board and the zoning board of appeals is, does this statute, okay, affect us and does it require us to get a permit? Why can't we get someone just to tell us that?
But I mean, if the overall theme is that we're grandfathered, in your mind, that's really all moot, isn't it?
Well, grandfather could be moot, but in the same breath, we're still looking at the issue of the statute.
Okay.
I mean, there's no, I mean, grandfather would end everything, okay? If the grandfather doesn't end everything, the statute, okay, and its application is very, very critical here. Okay, we tried to get a decision from somebody, okay, there's no procedure. Their procedure for us to get a finding like that is to file a completed permit application. And then they'll decide, possibly, if whether or not there's jurisdiction. That's not the way it should work. We should be able to find out if we're supposed to file a permit.
So one thing that I didn't ask of this, the town's position of violations.
Yeah.
Do you agree, Saul, that the February 24th, 2011 conditional use permit required, among other things, that Du Bois permit the CEO and town planner to come on the premises for annual inspections?
Yes, it did.
Okay, have Du Bois permitted that to occur in the last 2 years?
Yes.
When was the last time you permitted that to occur?
That letter there, we were trying to go back and forth to get the guy there along with the Department of Agriculture. Okay?
When was the last time you permitted that to occur?
Well, in September and before that, I mean, the last time we permitted them to do it whenever we can find the time, fine. Okay? We told them, yes, you can come on the property. We told them, yes, you can come on the property. We gotta find a time when we can get the guy from the Department of Ag here with us.
So your permission, your position is they can come on and inspect, but you want someone from DEP there as well?
Yeah.
At the same
Now,
time?
Not now, not DEP.
Who, on who? What
Department of Agriculture.
I'm sorry, Department of Agriculture. And has that occurred at all in the calendar year 2015?
No, it didn't.
Did it occur at all in the calendar year 2014?
No, it didn't.
Did it occur at all in the calendar year 2013?
No.
Did it occur at all in the calendar year 2012?
No, we were on appeal during that period. Well,
When was the last time it actually occurred?
I can't remember.
So
Since every-
since the conditional use permit was granted or issued in February 2011, there's never been a site visit permitted because,
No.
let me just finish
Make
it.
the word permitted.
Because, well, it's never occurred, because your position is it only can occur when someone from the Department of Agriculture is present, and you couldn't coordinate that happening, is that what you're saying?
Yeah, well, we were only contacted a couple times. Okay, and both times it just didn't work. And then we ended up in this mess with this, in October when the law became effective, okay, and at that point, okay, we needed to know if the law change, okay, affected what we were doing. Because we have a right to that. I mean,
I got the answer, thank you. So if I saw you wrong, I apologize.
I'm the president of, I wish I were the president. I'm the chairman of the planning board. Our policy for the past 7 years that I've been on the board is to authorize the town planner to determine whether or not an application is complete. And by complete, we mean, do we have enough information to make a decision at that point? There is an application on the website that lists a lot of the information that has to be submitted. The permit that was submitted in December 9th of 2014 had the first page filled out, and the second page has a very small section. There is an attached list that is supposed to be filled out. That list was not submitted, nor were any of the requirements from the licensing permit in 2011. Therefore, the town planner, based on what we, the planning board, have sent him, deemed that application to be incomplete. The Du Bois insisted that that was not the case. The town planner did not have the authority to determine that that application was incomplete. I wrote him a letter because I prepared the agenda, stating that the application was incomplete and listed the things that needed to be done. They objected to the fact that I wrote them a letter. In June of 2015, we had a hearing by the entire planning board, and we said, these are the items that need to be submitted in order to deem that application complete. They left. In July, they filed an application, and in August, when we went to hear it, they pulled the application.
Isn't that sort of though issues that have been presented to this board, twice within the last several months, and we've already ruled on those, that they're untimely?
Yes, sir.
So we don't, maybe that's not before us now.
Okay, I
Because
just wanted.
that's all been resolved, the appeals were not timely.
The applicant keeps saying that the town got an application, it was a complete application, we wouldn't rule on it. We never had a complete application to rule on.
First off, Your Honor, or Mr. Chairman, okay,
I like
it's
that.
fine.
I like this side of that.
You can comment. Just got a couple of points, Mike.
That was genius, by the way.
Wait, let me put something in the plus column.
Yeah.
All right, go ahead.
Got a smile too.
Okay, by statute, the planning board as a group is required, or actually by ordinance, okay, is required to determine whether under the solid waste rules, okay, an application is complete or not. We cited that to these gentlemen. It's around the land use ordinance 810E1. They were required to do that. Then the fact, and also, they never answered the fact that they allowed, they said, well, we deemed him to do this. You can't deem him to do that. It was an ordinance that was required to go before the planning board. And great, you did it, you let it sit for 4.5 months. I mean, why did it sit for 4.5 months? Can you answer that question?
Because it was deemed incomplete.
Who, by who? It was deemed incomplete? Who told us?
We're not arguing that.
Who told us? Well, it's an issue you guys wanted to raise. I think it's important.
It's an issue that you raised by bringing up the fact that you had submitted the application. I was answering as to what occurred after you got that application.
When did you send us notice that the application wasn't complete?
So let me interrupt, because I understand what you're doing, because I think the issues have been a little mixed
Yeah.
today. But I don't want anybody to do this to you, and I don't want you to do it to somebody else here today where someone feels uncomfortable. Let the questions come to us. Now, let the questions come to us. But that issue has been resolved by this board twice in the last couple of months, so I don't think tonight is the time to rehash that. What's before us tonight, as you correctly put in your appeal, is it relates to a notice of violation in orders to correct dated October 12, 2012, June 29, 2012. And then as you put, there's a second appeal with respect to this October 20, 2015 letter. That is what's before this board.
Right.
Okay? All right. Yes, ma'am.
My name's Diane Roberts, and I went to almost every single meeting when they got their permit back in 2011. I was sent notices from the town as an abutter, and I was there when they got their permit. There was a lot of discussion in regards to the bills. The whole purpose of having that was to ensure that they stayed within the amount of product that they were supposed to be bringing in. That was supposed to be the documentation that they were not bringing in more material than they were permitted to do. I went on the sidewalk. I was there for the sidewalk. There was a lot of discussion in regards to ensuring, because the land use regulations do not allow for them to increase this non-conforming use to any bigger, which also included not having another pad. All of these things were discussed. I was at the meeting when they agreed to the terms, the multiple terms to get this permit. And believe me, I spent a lot of time at those meetings. I still go to a lot of the meetings. I've seen the newest paperwork that's been sent into town hall. But I had a couple of questions. I want some clarification. The reason that I want this clarification is, are they or are they not currently today operating under a DEP permit?
You're asking us? So
Well, you said to
we
put
can't
it
answer that
through-
question.
I'm asking you so you can ask him, because you said to,
Go ahead.
The answer is yes,
Thank
we
you.
are.
all right.
Okay.
According to the DEP guidelines, it states that if you are going to have a DEP permit, you must be in compliance with all state and local regulations, which means when they got their permit to expand, they were not in compliance with the land use regulations because they hadn't renewed their permit. So for me, that's a huge issue. I brought it up to the DEP. And those items were agreed on for specific reasons. They were not supposed to have over X number of complaints. They were supposed to show the number of products. They were not supposed to expand, and there were a few more. I was there when they agreed on it. I was there for the last meeting when they were told that as long as all of this was done. Oh, and yes, they had to have the inspection, and they had to have something written by the code enforcement officer. And that was to ensure that everything had been adhered to in regards to smell, product, and space.
Thank you. All right, John and I have done a lot of questioning and commenting. Did either of the members want to ask anything, say anything?
No, I just feel like the grandfather thing is not, nowhere to be found, that's what they seem to be hanging.
Can I make one comment? When we made the application in 2012, of course we had a permit from the town. We got it February 11th, 2011, a 3-year permit. So we were permitted.
All right. Do you have any comments or questions?
Well, I would just like to ask this question. These land use ordinances are, for me, being part of this town, I think they're there for everyone. I mean, that's what the governing policies are. I mean, it's for the whole town itself. And you said at the beginning you didn't think that you needed to apply by those, and do you still feel that way for your business?
For the farm,
Right.
for that one particular area, the
Just
composting.
the compost.
Okay,
Okay.
and if we have field spread.
I wasn't certainly
The
clear to
farming,
me.
yeah, the farming part of it, okay. We have 4 or 5 other businesses, which were mentioned in the documents that we license them, okay, with the town and everybody else we're supposed to license them with. No, we're not saying we don't have to comply with the town
Just for
ordinances.
the composting.
Just in this one particular area dealing with farming,
Okay.
that's all.
I know you quoted that you run your business on best management practices. Who sets those practices? Isn't there standards that you have to meet?
Yes,
And who
and
determines it that you're meeting them at the best practices?
you have to go in with the NRCS, okay, and you file an application for best management practices. It's a nutrient management plan, okay? We've had one that's been in effect, for 4 or 5 years now. We've already started the process of getting the next one for the next 5 years. Okay, so we have a nutrient management plan that deals with the best management practices, and we've done that.
Is that monitored in any way? Who monitors?
Who
Whether
monitors?
you are in the realms of the best managing practices? How do they know that? You just say it, or?
No, you don't just say,
It's kind of like the water testing, it's
Yeah.
kind of,
we have
So do you have
certain,
documentations of that, how you comply for that?
yes, we have what they call, what's that, the water tests, okay, that test the compost that we use and stuff like that. They have
test some kind of-
watering tests,
You test the fields, what we spray
Yeah.
on, it's all part of the,
yeah.
Test the
part of
soil.
management, and what's wrong with
And
it?
who gets those tests? I mean,
The Department of Environmental Protection gets them,
NRCS.
NRCS, and Department of Ag, if they want them, we send them to them. That's-
I just didn't understand that, how you
Oh,
were
no,
regulated.
we're not unregulated, we're very regulated, okay? I mean,
That's up to date.
yeah, at one time, when we started the water testing, okay, we started with the new pad at the very end, so they could see how much of the nitrogen was being given off and everything else, and they were happy with that. And then they tested in our brook, okay, and then they discovered that it's Elmwood clay as well as everything else, so they modified that to where they test the beginning of the stream and the end of the stream, things like that. But we're monitored completely, I mean, there's no, well, another thing too, I have to say, you know, they talk about things that we agreed to comply with, okay? I have to go back to the very first requirement, where they wanted us to dredge the basin with vegetation and silt, okay? That would have gotten us, you know, our license revoked in 2 seconds. You can't be doing that sort of stuff. We told them that, okay?
It wouldn't have gotten there if it had been maintained as specified.
It was maintained as specified.
Always.
Always.
DEP come and check.
Yeah. You can't dredge
It
a
wouldn't have
basin.
silted if it was maintained.
It was maintained, you know, you're incorrect here.
So I just want to ask a couple questions. You heard Saul's position with respect to these site visits, that they want someone from the Department of Agriculture present. Has that been communicated to the town in the past, that that's who they want there when you come?
Yeah, I have had correspondence with both DEP and agriculture, but the third ruling authority would be the planning board. And what DEP is studying, what they're interpreting, may not necessarily be what this board is looking for. So I'm not arguing that there aren't regulations that they're supposed to adhere to. The argument here is that in addition to the DEP as a regulating authority, or the Department of Agriculture as a regulating authority, there's also the town of Arundel's planning board. And a lot of that information may help them in their decision-making process. But there's also the situation where a lot of what they're studying has no impact on what the board is licensing. And I think there may truly be confusion there. And perhaps that's never been articulated. I don't know. I'm charged with seeing that this ordinance is upheld. That's the reason for the notice of violation.
So you will make yourself available to do a site inspection, but you don't necessarily think you need to do it in accordance with a schedule that provides that someone from the Department of Agriculture will also be present?
That's correct. I don't feel that's necessary.
And then last question is, does the town still take the position that the boys must submit a permit renewal application to the planning board that fulfills all of the required submission criteria? All right. Yes, ma'am.
I want to make one thing that may need to be clarified in regards to testing. When the selectmen had a meeting a couple of months ago with the Department of Environmental Protection, I asked the question in regards to the testing. And the answer that I got was that all of the testing was done by the licensed entity, or in this case, unlicensed entity. So, to the best of my knowledge, all of the testing is done by Dupless, so it's not done by any other entity. I was not told that there was any testing by the DEP or the Department of Agriculture, that all the testing samples and all the testing is done by Dupless.
That's incorrect, okay, and that was not said. The DEP, okay, requires us to hire, like Kentucky, to do our water testing.
Maine certified.
Labs, okay. All the samples are taken to for the DeVars test. We send them to the University of Orono, up in Orono. Okay. No, we don't do our own testing. We do have a method of testing for our own purposes to check our own DeVars, okay, which we do ourselves, okay. But that's just for us. It has nothing to do with the testing that's provided to the state.
So, everybody good?
Yeah, did you take from the conversation that when the permit was initially issued, that the inspection by the CEO was not contingent upon having a DEP person or an agriculture person with it?
Right.
Thank you.
All All right, Saul, you presented your case?
I think I pretty much said everything unless you got more questions.
I think you did a good job. You guys present your case?
Anything else, Wilson?
I think you did a good job too. Any discussion beyond what we've already done? So let's deal with it in the order in which it's come before us. So the first appeal, there's two appeals by the boards, and they cited 11 grounds of appeal with respect to the issue of notices of violation dated October 12, 2012, and June 29, 2015. There's been discussion as to the timeliness of it. The argument has been that it's grandfathered. You've heard me state my position that I don't think it's grandfathered. But again, I'm one vote, so what is it?
So I think consistent with our past practice, I'd make a motion that that appeal be denied based on the fact that it's moved for lack of timeliness.
Second. All in favor? All right, so that one's unanimous. The second appeal starts at also 11 grounds of appeal. It's all unanimous. So Norm seconded it, John moved forward, everybody voted unanimous. The second appeal that the applicant asserts is again 11 grounds of appeal, claiming that the CEO of the town erred or abused his discretion and acted without jurisdiction when he issued a notice of violation dated October 20th, 2015. I'm going to say that again because that's important the way it's been presented. That the appeal is claiming that the CEO made an error, abused his discretion, and acted without jurisdiction when he issued a notice of violation dated October 20th, 2015. Any discussion about that beyond what we've already discussed? Any motion?
Okay, so I would make a motion that with respect to all three prongs of the appeal as presented by the petitioner, that none of those allegations occurred and that the appeal should be denied.
Any second?
Second.
All in favor? That's unanimous as well. All right, so that case is done. Wendy, could you just say for the record the time frame that they now have, and they have some time frame after today as well?
To appeal our decision?
Yes,
Yes, they, 45 days?
45 days.
45 days.
I just
It's
want,
Superior Court.
I knew that, but I just wanted it to be on the record.
Yeah, 45
Okay.
days.
Saul, I don't know if you were giving me copies of these, or if these are your copies.
Those are for the record, if you don't mind.
Okay, all right, so let's put that on the record then. So, the appellant, through the representative, gave me two documents during this appeal hearing. One is dated, two documents in addition to what they already filed with the town when they filed their appeal. One is dated July 9, 2015. It's to James Nagel from Du Bois, and it's in response to correspondence dated June 29, 2015. It's a 4-page document. The second is a 1-page document entitled the Rundle Land Use Ordinance 8.10.E.1, and simply cites what the ordinance says. So that's not part of it.
Chairman, my understanding is that your process is that at the next meeting we'll approve findings of fact.
That's correct.
And so, would it be appropriate for my office to prepare those, or would you do that
Yes,
yourself?
please.
So we'll have that to the clerk, the secretary, 1 week from, no later than 1 week from today.
Thank you.
And a copy to Mr. Fetter. The secretary will
Thank you.
give us your email address.
So the next thing on the agenda is to consider approval of the minutes and findings of fact from the November 18, 2015 minute. I'm sorry, a meeting. I have a copy of it, I assume you all do.
Mr. Chairman, the petitioner submitted that to us prior to the meeting, not sure that you were made aware of it.
Okay.
So the petitioner has some specific objections with respect to our finding of facts.
Okay, so I didn't see this, let me just get it.
So, I'm sorry, he didn't get a chance to read that yet. Thank you.
So has the town's attorney seen this? These are three legal issues.
Yeah, right there, that's what it's.
I haven't focused on this, Mr. Chairman. I'm happy to answer any questions to the best of my ability on the legal side, any of the points he's making here.
So let's just give, if you don't mind me asking you that,
Yeah, go ahead.
because I think the board should receive some legal advice on this. So if I'm reading this written document dated October 19, 2015 correctly, for the record, it's the Boys Livestock's objections to the Arundel Zoning Board of Appeals findings of fact and conclusions. And I assume it's the findings of fact and conclusions from November 18, 2015, or is it an earlier one?
It's the last, the one we're dealing with here, Mr. Chairman. We call it an objection because I didn't know any other expression to use for it, you know, be included with the consideration with the final draft.
All right, so thanks for clearing that up. So this document is associated with the appellate hearings that we've just had tonight?
No, the one before.
All right, so you're, okay, all right. So if I'm reading what you've written correctly, you put references, so it says Act 7, and I assume that means referring to paragraph 7
Yeah.
of the findings of fact?
Yes.
Okay. So I don't have a paragraph enumerated 7. Are you just counting down paragraphs, Saul? Is that what you did?
I think, James,
Maybe I have a different
no,
one.
I think this is what, I think that's what Saul was talking
Oh,
about.
okay.
You were tracking the paragraphs on the findings of fact, right, Saul?
Yeah.
All right, so that's what I meant. So I think I've got to clear up the record. You're filing this objection to the October 19, 2015 meeting, not the November 18, 2015 meeting.
October 19th, yeah.
All right, so that's what I thought. So it's not November 18th, it's October 19th.
Well, that's when we filed the appeal.
Right.
And it deals with the October, they call it the October 19th, even though it was November 18th.
All right, so then this is the question I
Yeah,
have
sure.
for the town's attorney.
Yep.
So number 7 of the findings of fact and conclusions of law references 10.5.c.4, that withdrawals of appeals will be without prejudice to the filing of appeal, and then apparently the appellant is setting forth an argument here in writing. So here's my first question. If we've already approved those minutes, is this something that should be discussed now or not?
Okay, these minutes were approved at your last meeting?
I think so, right?
No, it's just
October
been,
19th?
No, that's, he filed the application on October 19th. We did not hear the appeal until November 18th. So
So-
this is,
So why on the agenda does it say consider approval of meetings of fact from November 18th? So are you incorporating the minutes in both? Is that what I'm getting confused about?
we're doing the minutes and findings today.
Of both October and November?
No, just November. He filed it, he brought it into the town office on October 19th. The board did not hear it until November 18th. So it's our decision of November 18th that this is regarding.
in the draft, they refer to the time that we filed it.
I got it.
it.
So that's something that we
Yeah.
can discuss in an open hearing?
So this is still, I was reading the section, this is still unapproved?
Right, they're approving it tonight. They're making their
Okay,
decision
so
tonight.
then the question at hand is paragraph 7, it says, it talks about section 10.5C4 of your ordinance, which says, if a party does not attend a hearing and is not otherwise represented, its case will be being deemed withdrawn without prejudice to refile an appeal. Is that what we're talking about?
Yes.
And the objection is that the land use ordinances, to the comment, the land use ordinances governing 30-day appeal period might operate to render such appeal untimely. Is that correct? Is that what you're objecting?
Yeah.
Okay, so, there's a difference between, refiling the appeal. People could refile it, but the board doesn't have to find it timely. And I think that's what the board was attempting to express in that finding, and that's appropriate.
And then there's an objection to number 10.
Section 10.3C of the ordinance states that any aggrieved party may appeal the decision within 30 days after the applicant has been notified of the decision. And what's the objection here? There is no finding of what, if any, action on the part of the town of Arundel constituted notice to Du Bois Lobster of 10.3. There must be a finding as to what exactly constituted sufficient notification to Du Bois Livestock that set the 30-day statute running. The findings must be complete, succinct, and fully stated. I mean, typically, boards don't get involved in saying when the clock for an appeal starts to run. That's a determination that's based on case law and statute.
Okay, and I think there's another one.
And I usually take the most conservative. If there's any conflict, I'm appealing it, appeal as quickly as I can.
Oh, but isn't there a determination of when the 30 days start?
That's up to the applicant to determine when based on case law and statute.
Yeah, but I mean, they said we had not complied with the 30 days, and there's been no identification of what notification we ever received that started the application running. In other words, if you're going to deny our appeal based on a 30-day application, what started the statute that was submitted to the I understand that there's case law and everything else like that, and I was sort of swinging the other way, but they didn't think so. But I really feel it's important that they tell me what month started it, okay, or, which particular act did it.
Well, I think, again, to the town attorney, if you look at paragraph 9, in the findings of fact, we were talking about 2 potential trigger points during that hearing. One was August 13th and one was September 2nd.
Okay, so the first trigger point, August 13th decision was memorialized in a letter dated September 2nd, 2015, and the appeal was filed when?
I don't remember as I sit here, but it was after,
After 30 days.
yes.
Both dates was, 30 days beyond both dates.
So even if you took a very liberal interpretation that something had to go in the mail, it was, the September 2nd was mailed out, it was the last known address.
If there's another objection, which is, I'm sorry, that's it, right? Oh, no, there is another one. It says there must be a finding of what good cause is necessary to have a period extended.
I can answer that pretty quickly. The board's case law is clear that the boards aren't determining what good cause, the court determines good cause.
All right, so that's part of the record. All right, any motion to approve the minutes and findings of fact?
Are you gonna mark that as an exhibit?
Yeah, I just said we should, do we have a number? Yes. Just,
Oh, sorry.
no, that's good.
I make a motion that we accept the findings of fact.
Okay,
Second.
all in favor? Oh, you weren't at that.
Yeah, that's right.
You were not at that. Good.
I'm not voting anymore.
Can we do the minutes?
Yes, the minutes. So, you want us to now talk about the minutes?
You have to approve the minutes.
I thought that's
We
what we just
you
did.
just,
You just approve findings, like,
yep, make a motion that we accept the minutes.
Second.
There you go. All right, we have another hearing tonight. Thank you, Saul.
Oh, you're welcome.
We're gonna close it.
I'm just cleaning up my table here before we move to the other one, okay?
Thanks, all.
Thank you, guys.
Bring your own chair too?
I suspect we'll be back in January.
I'm tired by now.
Jack's
Tired from this board.
You don't realize, I know.
That was the deal. That was the deal.
Belfast to, get this one. 2 hours.
I did it in less than 2.5 hours.
Camera's right behind you.
Maybe like 2 hours. I was a big, one of these medical malpractice hearings and,
Oh, Cavalier.
yes,
Thanks for coming.
and yeah, there you go. 4 o'clock meetings.
Somebody's got the right chair.
That was me, I was sitting there, so I.
No, I was defending the hospital. That's why I feel like today I'm still on the course of that mention. I don't want to be on this. I'm not going to questions.
Jack wanted to know, get $35 for every time
Is everybody ready? Oh, wait, we gotta wait.
No, she had it, the printout for the second.
I have 7 hours of driving to do. Then I have meetings.
Thank you for that.
You want the front seat?
No,
Front seat?
we're paying those guys to be at the front seat.
You can have my seat right there, buddy. You're the big guy.
Come right up.
I was back there, I could hear you. You just couldn't see me.
There you go.
Oops, sorry, next week. Next time. That's not fun. 4 hours here and some.
All right, everybody ready? So what we're going to hear now is a request for variance by RSU 21. And if you wouldn't mind to identify yourselves for the record, that'd be great, and then I will identify the documents that have been submitted.
Sure. Kevin Crowley from RSU 21.
Thank you.
I'm Richard Spencer from Drummond Woodsum, and I'm the attorney for RSU 21. I'm John Kaczynski, civil engineer with Harriman Architects Engineers.
So we have a quorum here of 4 members of the board. I attended a site visit with Norm, with all 3 of you gentlemen on Saturday. We didn't, and Trey as well, sorry. We didn't walk around, but we discussed things and showed me the site plan and get a good idea as the other 2 of us. I want to identify for the record what you, excuse me?
You're in the site.
I am in the site. I hope the building withstands us. So with the application, we have 4 colored photocopies of photographs. We've got a deed from the town to RSU 21. We have the reorganization plan, submittal sheet. We have a list of abutters that were notified of this hearing. We have the CEO's November 23rd, 2015 letter to Attorney Spencer denying a permit. And we have the site overview plan. Did you submit anything else that I just neglected to cite? Okay, so why don't you give us your presentation, please?
Great, I'll start off quickly, just and thank you for the opportunity to come in front of you tonight. Thank you for showing up on Saturday and doing the sightseeing. You know, in a nutshell, this is really an inadvertent mistake. In 2008, when Arundel joined Kennebuck and Kennebuck to form RSU 21, the reorganization committee took this one big lot
and divided it into two. And it's really through nobody's fault, created two non-conforming lots. And Dick Spencer is here to talk to the technical aspects of that. And John Kinsiski is here to talk about the selection area. And I know that we'll work closely with the town's attorney to try to bring this into a conclusion that's good for everybody. So I'll just turn it over to Dick.
Yeah, thank you for the opportunity to speak to the board. What Kevin said is really a pretty good summary of what this is about, which is that when the Mildred L. Day School was built, it was on one lot of land that would meet all of the requirements of the zoning ordinance, because there's an extensive area of woods and fields to the rear, and the area that's covered by buildings is a very small percentage of the total lot. And when the school reorganization law was passed, it required, created penalties if school units didn't reorganize and consolidate into larger units. And it required that there be a reorganization planning committee formed with representatives of various communities that might consider being part of a reorganized unit. And that committee developed a reorganization plan. And in the reorganization plan, it said that essentially the front of the lot with the buildings would be transferred to RSU 21, but the back of the lot, the area with the fields, which are almost used exclusively by the town, would be transferred from the school department over to the municipality of Arundel. So that plan was developed by this committee, which was a statutorily mandated committee. And the plan was then submitted to the Commissioner of Education and approved, and then it had to be voted on. And it was voted on by what was then SAD 71 and by the Arundel Municipal School Unit. And they formed, the plan was approved. Well, the plan, nobody thought of it at the time, but more recently, the RSU has had a project approved to renovate this building, tear down part of it, and build an addition, and redo the circulation and the parking area. And so the code enforcement officer looked at this situation and said, well, I'm not going to be able to give you a building permit because you exceed the lot coverage requirement. And right now, on the front lot, the lot coverage is 30%, and it'll be 40% when the new project is built. And not only did the division of this lot do that, but it also made the town's property non-conforming, because that property is required by the ordinance to have a 50-foot strip that goes out to a public way, and it doesn't. So the reorganization plan managed to create, out of one conforming lot, two non-conforming lots for very different reasons. So in looking at that, it appeared, and this goes to the question of hardship, the only way you could solve this problem on this lot would be to tear down the school building, or half of it, to come within the 20% lot coverage. The other thing is that if this building isn't renovated, it's not going to be suitable for a school. It has very serious structural problems. The engineering reports say that it's a matter of time before it sinks. So that didn't seem like a practical alternative. So the RSU went to the Board of Selectmen and said, this situation obviously has to be fixed. And one way that we might be able to fix it would be if the Board of Appeals were to grant a variance based on this hardship situation. Then the RSU would deed the town a 50-foot strip out to the road, and then the town could deed the RSU the same area, same amount of land out of the swampy area in the back, and that would make the rear lot non-conforming. And so, I mean, would make the rear lot conforming. And so, I did want to bring one additional document, which came up at the sidewalk, which was the agreement between the RSU and the town, which is in the event that variance is granted, then the town and the RSU have agreed to do this land swap.
Who represents the town?
The Board of Selectmen.
I meant legally,
Bergen
Oh,
Apartments. Mayor
the,
Reagan, who's having
she's-
arm surgery.
she had to send her assistant
That's correct.
tonight because
We got the BT tonight.
Yes, Your Honor.
he is licensed to practice.
And are there any abutters here?
I don't know.
No, I was just asking.
Notices were sent to all of the abutters. And so essentially, what we're asking is that the board grant a variance for the new school project
Thanks.
on the grounds that it would be a terrible hardship if this property, which is a dedicated school property, couldn't be used as a school, and essentially it wouldn't have any economic value if it couldn't be used as a school, because it's not, first of all, it's sinking, and second, it's not adapted to any other use.
So it really is a DOE issue, it's not really an RSU issue.
I don't understand that question, but
But for the Department of Education, we don't have this problem.
They
Well, no,
didn't
it's
create
a-
the problem. DOE created the problem, so it's not
it was
self-created.
created by the legislature.
Right.
But I see the DOE as the bad guy here, the RSU is.
Reorganization.
Right. They didn't inflict it, wasn't
Yeah, what I'm trying to say is the
self-inflicted
RSU is collateral bomb damage.
ruin. Yeah.
Right, yeah, and in fact, the RSU didn't even exist
Mm.
when this problem was created. So, in looking through in the application, there's a little description of each of the factors that you need to consider, and we think that this meets all of the requirements. It's clearly a hardship. It's unique to this property. There are not very many other properties that have been divided in half by the Department of Education. It won't change the essential character of the neighborhood. Essential character of the neighborhood will be exactly what it is now, with a school here and residential properties around it. It won't set a precedent for any other situation, because frankly, I mean, I've been practicing law even longer than Leah's assistant, and I've never seen any like this anywhere.
Yeah.
Actually, does the school use the fields for any use at all?
The school uses the fields for, on a very occasional basis, but probably, I mean, the figure that I was told by Kevin was that probably 95 or 6% of the use is by the town, and the school uses it only, occasionally. So that's why the town wanted, I mean, I assume why the people from the town wanted to have the town own the fields. And if you think about it, the use on the whole property isn't changing. The whole property still has, if you combine the two lots, everything still meets the lot coverage. It's just that when you separate the town piece and the school piece, that you make them suddenly comply. So we think this is kind of a simple, straightforward variance request, and we'd urge the board to grant it. And it's going to be necessary in order for this project to go forward on schedule.
And it goes to Christmas future would be if the board doesn't grant it, that this somehow the RSU could keep get back the land somehow so it can go forward with this project? I mean, we force some sort of very conflicted situation.
You might force I mean, the RSU does not want to try to take the fields away from the town, but we would have to try to do that.
It would turn into a conflict.
And,
Could-
I mean, my own view is that we probably could be successful in trying to force that, but we don't want to do that.
Right.
And it seems ridiculous.
Who's maintaining the fields now, the RSU, town?
I want to always make sure we have a really good record, so what the town's attorney just commented on is an issue in my mind. So one of the possible resolutions would be if the town conveyed voluntarily or through court order those fields to our U-21. Is that a possible resolution? I'm not suggesting we do it, but would that resolve the non-conforming nature of the lot?
If they were combined into one lot, then it would meet the requirements. And then the question is whether, who has the power to make that happen. And if we said you have to do this, and the town said no, read the reorganization plan, I mean, I think it would create a disastrous situation within the RSU.
When is construction supposed to start? Is there a
Well,
start date?
They're hoping to have it start in April.
This, I go the way that you just
Yeah,
brought
so
up.
if we had to get into a long
Yeah.
process
Mm.
of trying to, somehow force the town to do this, we would probably delay the project at least, probably vastly increase the cost because the interest rates started going up today for the first time in 10 years, and they're probably going to keep going up. So the impact, first of all, it's not clear who has the power to make that happen, if anybody does. I mean, it would require a voluntary agreement, or we would have to, press a claim under the statute. And the reorganization plan says that they have to be divided, so I think it would create a serious problem for this project. And I don't know that it would be possible to resolve it in time for the project to go forward.
So going through the 5 criteria that you have to meet, as you know, you have to meet all 5 of them. So 2 of them in my mind are really easy. The granting of the variance will not alter the essential character of the locality. That's the easy one in my mind. As you presented, it will not in my mind. And the second one is by clear and convincing evidence presented by the applicant, the proposed use would not cause unsafe, unhealthy, or nuisance conditions. I think that one's an easy one too. I understand the hardship argument, and I understand the need is due to the unique circumstances. The one that I just want to make sure that we create a good record on is the land in question cannot yield a reasonable return unless the variance is granted. So if you wouldn't mind just spending a little bit of time repeating your position on that issue.
Yeah, I think there are 2 answers to that. One is, this property is dedicated to school purposes. So it's not, in fact, it's not a financial operation. So the standard of earning a reasonable return has to be interpreted for a school property. And the answer to that is that without the variance, this property cannot be used productively for school purposes. So that's the first thing. I think you have to interpret what sounds like an economic standard in the zoning law. You have to make that apply to an educational property. But even if you didn't do that, the reason the property wouldn't earn a reasonable return is the current economic use of the property is as a school. The current school exceeds the lot coverage requirement by 50%, the proposed school would cover it by double. So in order to meet the lot coverage requirement, you would have to tear down a lot of this building, number one, and then you'd have half of the school building on a piece of land, and that would have essentially no economic value. Who's gonna buy that and try to make an economic use out of it?
So I appreciate, John, that you're here today with the applicants. Is there anything that you can add to what Richard just said about that?
Yeah,
One simple question I have, and you can answer it as broadly as you like, but as part of this plan, I assume projected costs have gone into it, right? There's been a projection to the RSU 21 as to what it will cost to do these renovations. Has there also been a projection as to what it would cost if this variance weren't granted and you would have to knock down part of the building?
Well, we haven't actually included that in our estimate. Our estimate was based on tearing down C and D wings and building the new wing as shown on the plans, and adding the new pervious. And that was all felt for the referendum question, so there's a great deal of effort that's gone into the process through construction manager and with Aaron Architects, developing that cost estimate. So that is a very fine-tuned animal for this project. And there's not a lot of room, there's not a lot of extra money in there for delays or just tearing down the building. You know, basically, the school will not function to serve the population that's in Arundel for the students.
And thank you. And
If you did when I said you have to tear down part of the building, you have to tear down part of the building and not build the project. So what you end up with would be half of the school on this property. So you'd have to spend money to bring it into compliance. And then you have the property with half of the school on it. And it wouldn't meet the educational needs and wouldn't be well suited to any other economic use.
right, so I'm not someone who's into hyperbole or drama, but if that happened, basically the school gets shut down.
Yeah.
Isn't that the reality of it?
That's the reality.
And which is the last thing the RSU wants to see.
Right.
And I think town too.
And you said it, but I just want to make sure I'm clear. This Exhibit A on the memorandum of understanding between the board and RSU 21, you showed it to the three of us at the site walk with John. What's here is it looks like little squares.
Yeah.
That's the swapping of the land for that.
I saw
I
that.
have it color plan here if you want to look.
Green or red.
All right, there you go. I didn't even see that.
We have multiple copies here.
So it's
So I might as well use it there, John.
So this is the 50-foot wide strip, roughly paralleling the river property line, which will get the town's lot frontage on Limerick Road. And then this is the equivalent area of this strip to then swap. So the land area stays 9.59 acres, which currently sits at division from the DOE agreement. In my office, I'm calling it the swamp. Yeah, I mean, access is still going to be by the right-of-way, this vehicular access to the fields is still going to be the right-of-way easement across both the main Turnpike Authority land and the RSU lots, the Little Days. There's still access, but the ordinance requires that there be a 50-foot strip in frontage. So that's why we came up with the idea of giving the town a 50-foot strip, but we didn't want to make the lot coverage problem worse by doing that. So we got them to agree that they would give us the equivalent areas.
Did the Turnpike take any variance from Arundel when they did expand that third lane?
I don't know. The Turnpike does own a lot between their right-of-way, as shown here, it wraps all the way around the whole thing. It's some very thin width here, but it's a lot of land not associated with the right-of-way, but it's a separate lot of land owned by the Turnpike Authority.
Because they own the property on the other side of the bridge, right? Because they have a little staging area there.
Yeah.
Well, they own the property actually along the road here.
Right.
And there's an easement. They own this little strip. This little funky strip here. This is where you, when you came over the bridge and you turned here, you actually went across
Right.
Turnpike land, and they have there's a 50-foot easement over that to get into the school property. So it's funny, but this little strip here is still owned by the Turnpike. But it's a separate lot, it's not a separate road.
Yeah.
I just want to make sure that you have in the record the memorandum of understanding between the board of RSU 21 and the municipal office with the town of Arundel that Richard handed us at the beginning, so that's part of it. I have enough information in front of me. If anyone says any more they want to ask or discuss, I'm happy to hear it. Yes, sir.
Yeah, can I make a statement, please? The applicant said that, or claims that this would not be setting precedent, but I think indeed if you grant this, you would set a precedent, because the access that is being proposed is really unbuildable. So it is an access on paper only. You cannot, because it goes across swampland. I mean, you probably could build it, but it would be hugely expensive. So you would be creating then a lot, or you would be allowing the creation of a lot with technically no access but for an easement. And that is not what the ordinance intended.
Are you talking about the green spot or the?
No, I'm talking about the access that they're proposing right up here. Not good when you're flipping over the street. This access way to satisfy the ordinance goes through wetlands, which is really unbuildable. No, this is the right-of-way that they're proposing.
That's an existing.
Existing road,
existing
right,
right-of-way.
existing right-of-way, but to meet the ordinance for the frontage, you're proposing this swap, well, this swap of land, I guess we read, right? Which is, goes through very, very, very wetlands, across the stream, and technically, you could not build an access there.
Correct.
So,
But the ordinance doesn't require the access. I think that's correct. I mean, I think he's correct.
well, I think it sets a precedent that you would allow that kind of finagling to take place, where you could have a back lot without technical access.
And I think there is technical access because there's a deeded right-of-way over this driveway coming to the back lot.
Over what? Yeah.
Over the road. But the ordinance,
Right, but
the ordinance as it's written, says that it's not enough in the ordinance for a back lot to just have an access easement. The ordinance says that it has to have a 50-foot strip owned in fee to the road. And that's true. And so one of the ideas that we looked at, looking at the whole plan, was, okay, why don't we deed the road to the town, and then in a 50-foot strip, and then they'll have this 50-foot strip going out to the road. The problem is when you do that, you cut off part of the existing lot, and then you make the lot coverage problem worse.
well,
So-
you could still do the same thing, you know, with doing some land swaps that you're proposing now.
Well, when we considered this idea, what it actually did was it created a whole new lot, because it separated the land to the, below the 50-foot strip from the rest of the property owned by the school. So that was, and what the ordinance says is it says that there has to be an owned 50-foot strip to the road. So this meets the ordinance in terms of the practical access for the town. It provides it over the road. And so we think that this was the best plan we could come up with to meet the ordinance and solve this problem.
I just want to make sure.
Well, yeah,
Based
that's
upon these
allow
comments,
state lots without any
is
action.
there a suggestion just as we even get another conforming problem? No, I mean, if we agree to this, does it create another non-conforming issue?
No,
No, I would just, okay.
no, if we tried to do it the way I first thought of doing it, which was to give a 50-foot strip where the current road is, that created another non-conforming.
That's right. Okay. Any comments or questions?
No.
So we haven't done a variance, ready to vote?
Where is the current
Yep.
non-conforming?
That supports the.
This is the road, if you convey this 50-foot strip to the town, and then you cut
Oh, I
off
see,
this
so
piece.
you'd have it all.
But if they,
Then you have
grant
another,
this,
under RSU laws, another non-conforming. Can you make a lot coverage?
I would,
Richard, do you have anything else you want to present?
No?
John, you good?
good.
Kevin? Okay.
Make a motion. Oh, go ahead.
So because we haven't done a variance as a board in a while, we should go through, in my opinion, all five, this complete discussion for the record of all five criteria that must be met for the variance to be issued again. So John, if you wouldn't mind taking the lead and just.
So, with respect to issue one, which I think of the five we've all agreed is probably the most difficult, in addition to the arguments that have been made, in my mind, what's unescapable in this with respect to the economic return is that this is the rare instance where you have a variance that involves government entity on government entity crime, if you will, that you are forced by the Department of Education to take action, and you did. So I don't think that the same kind of balancing test that this board has engaged in the past is necessarily the same as it would be with private citizens or other entities. And I think that's what really distinguishes this from everything else that we've done, and that's why I feel that this does not create a precedent of really any kind unless government entities are involved. And the last thing that I think that's inescapable that I think we have to consider, and it has to be at least somewhere in the back of our minds, is that the introduction of the RSU, or the marriage, I guess, of the RSU between Arundel and Kennebunk was born through the will of the people. I mean, it may have been forced by statute, but at the end of the day, the citizens voted for it. And so I think for that reason, that criteria is met. And as I said earlier, I think that last four criteria with respect to all five are easy, no-brainers, and that's my position. And for that reason, I would be prepared to vote in support of the RSU.
Do you have any comments or thoughts or questions? You want me to?
Yep.
All right, so let's make a motion.
Go ahead. Okay, I'd make a motion and as presented, with respect to the variance request, that it be granted in its totality as requested by the RSU and supported through the agreement with the town of Arundel.
And to further state that all five criteria.
Oh, and all five criteria is absolutely been met, and I have no problem with that.
I'll second that.
All in favor?
So in terms of the findings of fact, we heard that John made some very specific findings on criteria one. As far as findings on the other criteria, am I hearing that the board is pretty much in agreement with the argument set forth in the applicant's?
100% agree.
Right,
Yep.
okay, so we can work with that.
Yep.
Could I make a request that in the findings of fact, you make John's statement very clear that this is not intended to be a precedent of any kind?
Yes,
Because that's
the will of the.
Yeah, that's fine. I think he presented that very astutely and politely. That should be part of the findings of fact.
Government on government crime. Stop government.
Write it down, baby.
All right, thanks very much.
Thanks, everybody. Thank you.
Thank you, guys.
It's always good to see you.
Yeah. Yeah.